All right, I'm going to take this natural hush that's descending as my cue to start. For those who don't know me, my name is Agnieszka Sobocinska. I'm a professor of global history and director of the Australia Studies Institute here at King's College London. It is tonight my sincere pleasure to welcome you all for the 2025 Trevor Reese Memorial Lecture. The Reese Lecture, as many of you know, is given annually in memory of Dr. Reese, who was a distinguished historian of the British Commonwealth and Australia and reader at the Institute of Commonwealth Studies, which was the Institute's home from 1982 to 1999. It's my pleasure to acknowledge members of the Reese family in the audience tonight, and they've been here for many years coming to these, so it's a real pleasure to have you here again. So each year, the Reese Lecturer is an extraordinary early or mid-career scholar working on the history or politics of Australia. Previous Reese lecturers have included luminaries such as Stuart McIntyre, Frank Bongiorno, Joy DeMusi, and Shirlene Robinson. Tonight, I think we're in for a real, very special treat. The lecture is being delivered by Associate Professor Alecia Simmonds. Now, Alecia is a multi-award-winning scholar and writer, and I'm sure tonight you'll find out why. She works at the interface of law and history. Tonight's lecture presents research from her most recent book, Courting: An Intimate History of Love and the Law. This wonderful book has collected the New South Wales Premier's Prize for Best Book in Australian History, the Australian Law Research Award for Best Book, the biannual Hancock Prize for the Best Book, and the Australian and New Zealand Legal History Award for Best Book. It is very, very good. I finished it last night. I cannot stop glowing about it. It was also shortlisted for the Prime Minister's Award and the Ernest Scott Award. Alecia's first book also was prize-winning. She for Best Crime Non-Fiction. She's published in national and international journals on the relationship between law and imperialism, gender, race, and intimacy in Australia and the Pacific, and she also publishes in the mainstream press. She's a chief investigator on an ARC discovery project entitled Women's Century of Struggle, Juries, Justice and Citizenship, and is the current recipient of a grant by the Francis Forbes Society, enabling her to conduct research on how defamation actions were used in the early 20th century to protest race-based harms. As I said, we are in for a real treat, so can you please join me in welcoming Associate Professor Alecia Simmonds.
Thank you so much, Agnieszka, for that very generous welcome. I'd like to begin by acknowledging the Gadigal people of the Eora Nation, upon whose unceded lands my book and the research for my book was written and conducted. They're the original historians and storytellers of the Sydney Eastern area, which is where I wrote my book, and I also wrote this lecture. And I'd like to acknowledge their elders past and present. I'd also like to thank the Reese family for their generosity and their commitment to building a public intellectual culture, both in Australia and in Britain, and to the Australia Institute, so at King's College, for inviting me to give this lecture. It is an extraordinary honour and privilege, and one that's been extended to so many of my favourite Australian historians, including among the people who you mentioned, Agnieszka, my own former PhD supervisor, Penny Russell. She told me that she gave the Reese lecture one year, which was lovely, about 20 years ago. So I'm very grateful to Agnieszka for inviting me, and London is, as ever, an absolute delight to visit, particularly on days like today where you wake up and you're like, blue sky and autumn. Extraordinary. I have to get out in it. Okay, so I'm going to begin my discussion on the history of love and law. So I'm going to begin with a story. On a near-perfect autumn morning in Sydney, March 1914, Beatrice Story, a barmaid, sued Frederick Chapman, a farmer, for abandoning her on the day of their wedding. To be precise, she claimed £1,000 damages in the New South Wales Supreme Court for breach of promise of marriage, a suit that could be used to claim compensation for injuries arising from a broken engagement. Beatrice had first glimpsed Frederick 1 year earlier from behind the bar at the Captain Cook Hotel in Sydney. Cavalier, stocky, and a spinner of yarns, he breezed into the pub, smelling of horses and flashing his winnings. He told her that he'd been at the Moore Park races down the road. He also said that he was 40, wealthy, and a widower. After a month of giddy infatuation, he presented her with a wedding ring and vowed that he would marry her. Almost none of what he told her was true. Beatrice explained from the witness box to the judge and jury of 4 that she was 30 years old when she'd quit her employment on Frederick's insistence and moved back home with her mother, a few doors down on Flinders Street in Sydney. Yes, she said Frederick had made wedding arrangements at St Barnabas Church on George Street in Sydney. 40 invitations had been sent out, she said. The wedding cake and carriage were ordered. She'd selected furniture for their new home in Kensington, and he promised to settle property upon her, as well as gifting her £2,000 to furnish the house. And I quote Beatrice, she said, "Oh, he said he had plenty of money. In fact, money to burn." The day before the wedding, Frederick kissed Beatrice goodbye on the porch of her brother's house and told her not to be late for church. Frederick never showed up for his wedding. He phoned Beatrice and apologised, asking her to cancel the ceremony as he'd just received news that his wife was alive. The marriage, he said, would make him a bigamist. Beatrice was livid. Frederick rushed to her house and tried to console her, begging her to take the wedding ring, fumbling his way into an embrace, chaotically trying to kiss her. She pushed him away. In the following weeks, Frederick turned to ink and paper, and we have some of Frederick's poetry there that he sent Beatrice. And this is published in the newspaper. You know, any breach of promise case would be heard, the evidence would be submitted to the court. The newspapers would then ask for the evidence and all of the love letters. You'd get these massive kind of, you'd open up the Sydney Morning Herald, big broadsheet, and there would be the entire court transcript and every love letter that had been written. And that would then be picked up around the British Empire. So they would then republish that in South Africa, Hong Kong, Britain. They were the celebrity gossip, basically, of the day. So there it is. That's some of the poetry that he wrote her. Bewailing the maddening effects of passion, confessing that the reports of his wife were a yarn, and exhorting that it was his greatest wish to marry. Beatrice converted Frederick's love letters into legal evidence and his passion into proof in one of the most lucrative breach of promise actions of her decades. She got £350 compensation for her lacerated feelings. The next time Beatrice and Frederick appear on the historical record is the 23rd of January 1915 at St Martin's Anglican Church in Kensington. This time, Frederick showed up for his wedding. A little under 60 years later, in 1973, a grandson of Beatrice and Frederick was also threatened with a breach of promise suit, 3 years before the action was abolished. The matter was settled, no newspaper bothered to report about it. In fact, we only know of the action because in 1986, a Liberal member of Parliament in Australia, Wilson Tuckey, raised it in federal Parliament. Paul had a girl called Christine, he hissed, directing his comments at a Labor MP named Paul. "Madam Speaker," the Labor MP interjected. He demanded that Tuckey be censured. He railed against him, calling him a criminal. Later that day, the Labor MP held a press conference outside Parliament House to address the remarks and asked that they be erased from the official Hansard minutes, so the official minutes of Parliament. This Labor MP, the grandson of Beatrice and Frederick, was the future Australian Prime Minister, Paul Keating. So he's got breach of promise in his family. The question that I have apart from that is why Paul Keating would care so much about a past breach of promise suit. An action which by that stage, by the 1970s and the 80s, was seen as a kind of quirky relic of the Victorian era. Why should we care about breach of promise suits? This very tiny corner of the common law, or in fact any action over a thwarted romance in the past. And what can these minor tragedies that we see in breach of promise cases tell us about the history of love over the course of 2 centuries? And what might they suggest about how humans have sought to govern love, that most ungovernable of emotions across time? So these are just some of the questions that I hope to have answered in my book, Courting. In this book, I use litigants' life stories to unpick the entangled histories of love and law, tracking how these 2 institutions became separated over the course of the 19th and 20th centuries, and to explore what breach of promise actions tell us about the history of love. So if Beatrice's story had been left at the altar today, for instance, Frederick Chapman would not have been forced by the state to compensate her for her hurt feelings, nor for any financial losses that she incurred. The very fact that Fred was an intimate rather than, say, a commercial partner would likely have denied her a legal remedy. The breach of promise action is now abolished in Australia, at least. It continues in Israel, interestingly. And the law today generally presumes that intimates don't intend to create legal relations. Women are not economically and socially dependent on modern marriage as they once were. And a failed relationship does not relegate women to the status of damaged goods. Courtship, we say, is now defined by love, choice, physical desire, and mutual negotiation, rather than by contractual legal obligation. Fueled by dating apps that promise a new partner by simply swiping right on your phone, fantasies of romantic plenitude have replaced legal regimes of punishment. But people do continue to experience injury, be it financial or emotional, when intimate promises are broken. And the consequences of romantic deceit can be life-altering and particularly complicated if there's a kid involved. So rather than seeing the unmooring of love from law as a tale of liberation, which is the way that this history of this suit is usually told, it's told as a moment where love is set free from the paternalistic bonds of the state, I question in my book what we've lost actually in this process and how we might imagine legally and socially an ethics of intimacy. Instead of turning to law, the Beatrice story of today would likely try to overcome her pain by reading self-help books or turning to friends, family, and experts, all educated in varying degrees in psychology. The advice that she'd received would no doubt revolve around the virtues of resilience, the balm of commodity culture, go out and buy yourself a new dress, a new lippy, and an interrogation of her own psyche. When somebody's dumped, we tend to ask, why had they been attracted to such a duplicitous cad in the first place? We probably don't use those words, but that's what we ask. In the contrast between past remedies and present-day solutions, we can observe, I think, and this is one of the arguments in the book, a shift in the governance of love from law to psychology. And where law would have ascribed fault, it would have demanded a tallying up of emotional, bodily, and financial harm that could be compensated, however awkwardly, by money. Therapeutic discourse or psychology is uninterested in material loss, or, this is debatable, ethical responsibility. But what was once a public debate about the rules of romance, including its gendered financial costs and the seriousness of its injuries, is now sequestered away into the therapist's clinic. The stories in my book, when viewed as a whole, and the first one starts in 1806, the last one is in, I end the book with the abolition of the action in 1976, the last one sort of around the 1930s. They track how and why that change occurred. So like scholars before me, I argue that the coming of the counsellors by the mid-20th century is not a victory, but a loss, particularly for women, as responsibility for romantic injury was individualised and feminised, and its pain trivialised or drained of economic meaning. Okay, so to see what's at stake in a breach of promise action and to demonstrate how a historian might read these cases to illuminate the history of love, I'll offer you some exemplary cases from the 19th and 20th centuries. But before I do that, I thought it would be good to just start with a quick note on what the suit is, a bit of background to it. So it has its origins in medieval canon law, British medieval canon law, dating back to the 5th century, that allowed jilted lovers to sue for specific performance. So if there's any lawyers here today, specific performance in contract is where you ask for for the particular act to be performed. So in this case, you're asking for the marriage to be enforced. So it wasn't money they got a husband or a wife. And men used it actually originally in the medieval period as much as women. And that was the case up until the 19th century. The 19th century really sees the suit becoming feminized. Okay, so to make out a case, you have to ask first, is there a promise? It can be either express or implied. And secondly, had the defendant broken it? The defense then would argue a defense to the breach, which is usually unchastity. So that's the main defense that they use in the 19th century, that the woman is unchaste. And unchastity means, as you would imagine, that she's seen as promiscuous or whatever else. But I also found cases where a woman was deemed to be unchaste because she laughed too loudly in public. Another woman was seen as unchaste because she was overheard at the ferry saying, damn it, the ferry is late, unchaste. By the 20th century, that is, it moves to mutual exoneration. So the idea that both of them have agreed to end the relationship, which suggests a lot about, growing women's autonomy in that time. It's not until 1871, or the 1870s generally across Australia, that the plaintiff and the defendant are permitted to give testimony. So before that, look, and I say this in they're the rules, that's the legislation. The thing that I found in Australia is that at least until 1810, no one is trained in law. So half of these things don't actually matter. Like, the judges sort of try to wrestle with it, and, usually they don't adhere strictly to the letter of the law. And even after that, I found that there are often plaintiffs giving testimony. But generally, because they weren't allowed to, it meant that you would then bring in all of your neighbours. Like, it's the neighbours, it's the love letters that would be read for the contract. They would look at the particular ways in which you began it, dear blah, blah, how many kisses. And you can see, and that would be given contractual meaning. And you can see that when you go to the archives, because you can see the parts that the judge has underlined and will often write near it, contract. So it's a kind of a complete sort of translation of emotion into a kind of a legal meaning. So it's not until 1871 that the plaintiff and defendant are permitted to give testimony, but the New Evidence Act stipulates that the plaintiff's evidence has to be corroborated by some other material evidence. And that's significant in that it's the only action in the civil law that demands that of a plaintiff. And the reason for that is that it's assumed that women are lying. Prior to this, the risk of perjury was considered to be too great. That was the reason as to why they didn't allow the plaintiff or the defendant to give testimony. And it wasn't just in breach of promise. It was in almost all civil and criminal actions. You couldn't, if you were too close to it, you weren't allowed to give testimony, which I think is very interesting when you think about that in terms of histories of evidence. Today, you want to be close to it. We have that scientific kind of idea that the further back you are, the worse it is. Whereas then it was quite different. It was this idea that you're corrupted by it. They're inferring romantic gestures from working out together, frequent visitations and gifts, or reading contract into the love letters. The last stage of the suit is the assessment of damages, which a jury would determine if it was heard in a lower court. And same actually in the upper court. So generally when it went to the jury, the plaintiff could claim for general damages or damages arising naturally from the wrong. So that's your main body of damages. And they were called, you would sue under lacerated feelings. So that was what you're suing for, or for loss of settlement. And loss of settlement meant how much the guy was worth. And it's an interesting contrast, I think, in Australia and the UK cases. In the UK, from what I've read in the scholarship, any cross-class cases are viewed with suspicion. It's assumed that the woman's a gold digger and that she's just trying to get money out of a guy. That's not the case at all in Australia. They're almost all cross-class, and in my book, almost all the women win, at least throughout the 19th century. And in the 20th century, it's a bit more mixed, but it's still weighted very heavily in the woman's favour. So you're suing for lacerated feelings, you're suing for how much the guy's worth and how much you would be worth if you got married. And then in the 20th century, there also appears a thing called special damages. And that's where you start to sue for your bodily injury. So, and I'll talk about that. So women start to claim psychosomatic harm. You're suing for the cost of the trousseau. Or in Beatrice Story's case, she goes, well, I quit my employment. I want money back for that. So they're suing for those wages as well. Okay, so I'll move to the very first breach of promise case that was brought before a jury, which is Cox and Payne. Okay, so Sarah Cox, I have a picture of her somewhere. There she is. That was her, a little bit older. At the time that she brought this, she was 18 years old, a fiercely independent working class woman who had met her lover, the aptly named Captain Payne, whilst residing at her employer's house. The whole case is quite ridiculous. He's called Captain Payne. He accuses her of dating another man called Mr. Suitor, and his name is really Mr. Suitor. So the barristers have a ball. They're like, perhaps he wasn't the only suitor who would suit her. This is terrible. Payne. Anyway, so she meets him at her employer's house, and this is very normal for working class women to meet their partners in that way. And she's working as an apprentice seamstress. Charles Wentworth, who goes on to draft the New South Wales Constitution, ends up being a very significant barrister, starts the Australian newspaper, becomes one of the wealthiest pastoralists and landowners in the country. At this stage, 1825, he's barrister, and he's representing Sarah Cox. And he explained to the jury that Miss Cox, he says, was possessing of some attractions, which apparently won her the attentions of the captain, who first sought her parents' approval and expressed a hope of being allied with the family. Miss Cox's parents acceded to his request, and their romance began to blossom. And he says love letters passed between them couched in terms of the strongest affection. And Cox's employer testified, so she stands up and she testifies to hearing Captain Payne make love to the young lady. 1 year later, Payne's announced to Cox's sister and to her parents his intention of marriage, vowing, in his words, that his eyes might drop out of his head if he did not fulfill his promise. Yet for all of his effusive declarations of love, Payne's eyes did not drop out of his head, but rather became distracted by the charms of his other female acquaintances. Unbeknownst to Miss Cox, he began courting another woman called Miss Redman, whom he soon abandoned in favour of marrying a wealthier widow by the name of Mrs. Leverton. Upon learning of his perfidy, Miss Cox released a volley of letters bursting with invective at her ungrateful wretch of a lover. Unaware of his forthcoming marriage to Mrs. Leverton, she sought to clarify the status of their relationship. If you've changed your mind, she wrote, I ought to know as soon as possible. Her mother and close friend Mrs. Beckett also confronted Captain Payne, demanding an explanation for his deception. According to Mrs. Beckett, Captain Payne was nonplussed by the interrogation, casually remarking to Mrs. Cox that promises and pie crusts were made to be broke. The jury did not share Payne's libertine approach to relationship, finding him guilty to the substantial sum of £100 damages. So that today would be about $180,000 Australian, which is £90,000 UK. Now, one of the delights, that's the story that I read in the newspaper. That was my first hint of it. You know, I researched this first through Trove. And then I went to the archives, to the State Records Office. And to be honest, it was such a shock when I first started researching breach of promise, because I expected to find this kind of thing here. So they're called the judgment papers. And this is the Cox and Payne papers from 1825. I expected to find, you know, bills of cost, summonses, affidavits, you know, all that kind of stuff. What I didn't expect was to see every love letter that they had written suddenly tumble out, you know, of the judgment papers. And as I went on researching it over the centuries, over the 2 centuries, you know, there were just remarkable things that people had submitted into evidence that are now kept still in the State Records Office. So, you know, I've got a chapter on a Syrian hawker who stitched a bit of antique white lace into her letter to her lover, Moses Hannah, who ran a warehouse in Redfern. And she said, you know, I want a little bit more of this lace. Make sure you don't put the price on it so that I can up the price, you know. And that lace is still there. Found train tickets, found lockets of hair. There's a very visceral, you know, kind of quality to researching it. And I think that the other significant thing about this is that it turns the State Records Office into a museum of working class love. You know, like when you look at histories of love as they're generally known and they're generally written, they are histories of the bourgeoisie and they're histories of the aristocracy. What we know about the love in the 19th century, we know through Jane Austen and we know through, you know, ridiculous things like Bridgerton or whatever, you know, and this tells a very different story. You know, it tells a story of working class people, which and they were largely the people who would sue, or almost exclusively the people who would sue, particularly in the 19th century. If you're a middle class woman, you are not going to have your feelings filleted before a public audience. You know, you would blink in the glare of the public. Okay, so how do we understand that particular case? To some extent, you could see the court's unsympathetic appraisal of Payne's conduct as part of a broader campaign launched by colonial authorities to impose an official model of marriage, sanctified legitimate heterosexual unions, upon a recalcitrant working class population. So convicts in the early colony largely shunned marriage, preferring de facto unions that lasted around 10 years instead. They'd place advertisements in the newspapers self-divorcing. They had children out of wedlock. For instance, in 1806 in the colony, there are 1,800 children born, and of those, 1,025 are illegitimate. Sarah Cox is illegitimate. She's a product of a bigamous relationship. William Charles Wentworth is illegitimate. The judge who hears the case has about 3 illegitimate children running around. They're all pretty loose. So all governors are given instructions to encourage marriage, but this isn't really enforced. It's not really taken up until Governor Macquarie arrives in 1814. And he issues a series of proclamations demanding that citizens marry, offering property incentives and inheritance rights for those who marry, and taking them away for those who don't. Why the sudden change? You could generally see it as part of a British Empire-wide rise of evangelicalism, around this time. And more specifically to Australia, you have a shift from the penal colony to free immigration. And with that, you have a shift towards respectability. The colony had a reputation at that time, and I quote, as one vast brothel. And the best way to change this was to encourage the population to become respectable, and marriage was the fundamental marker of respectability. So although private in nature, promises of marriage then for breach of promise, this is why I think this case sort of sits at the cusp, are a very serious public consequence in a context where sanctified and legitimate heterosexual unions are considered to be the foundation of the moral and the social order. One of the things that I found interesting in researching the book was if you compare it to the UK, US, Canada, anywhere else, there's a lot of cases going on in the late 18th, early 19th century. In Australia, I found 2. This is the very first one that's brought before a jury. Prior to that, I found 1. So it started with that absence and why that was. And I think that it's largely because the convicts didn't, like most people, just didn't care about marriage. And it's the moment where they start to get property rights, they start to have that enforced, that you start to then see a huge uptick in these kinds of cases. And you can see what's at stake. The Hobart Town Chronicle in 1833, commenting on a breach of promise case, said, if such a line of conduct, referring to the man breaking his promise, were to be tolerated, what would become of our little community? Who would be safe? What forms the colony? What renders it worthy of its name but its respectability, the virtuous and honourable character of families of which it is composed, but especially the fair, unblemished fame of the female proportion of them? So to this extent, it's not just women. I feel like a lot of history talks about the need for women to exhibit sexual restraint. Absolutely. But so did men. The degree of lasciviousness, I think, which men were socially permitted was subordinated to marriage, which was seen as the foundation of civilized society. And that explains the tone of high seriousness in Captain Payne's letter to Sarah Cox. It's hardly romantic, the letter that he writes her, asking her to marry. He says, I think it is my duty to inform you that my affections for you are founded upon the most honourable and pure motives. They have not been sudden nor precipitant. And she goes, all right, I will marry. So love is particularly serious for women, given that marriage is their only socially acceptable vocation, or their future economic and social status depends upon men keeping their promises. So, you can see breach of promise at this time as providing financial redress for very real, injuries that are suffered as a consequence of a broken engagement. But it also, you're seeing the courts performing a kind of pedagogical function. They're teaching incorrigible libertines like Payne to uphold principle and propriety in love. It protects the reputation of the plaintiff and gave the courts an opportunity to channel love into socially appropriate forms and to bring intimate lives into a civilized frame. I think one of the things that I found when I was researching it was that as much as the courts try to do this, I think when you look at the cases and all of the material that's submitted, all the love letters, you can see that love is in fact subject to its own laws, that it has its own kind of informal mechanisms, like regulatory mechanisms that kick in. So we see that in Cox and Payne. You've got Captain Payne swearing an oath to marry Cox. He's going to pluck out his eyes, if he's not good, true to his word. He invokes God as his witness. We see the lovers writing love letters as a way of outlawing the amorous laws that the others have transgressed. It's very much the way that love letters are used. They argue through them, and you can see that as a kind of normative debate or informal legal kind of debate. They demand action and they issue punishment. And they're presided over by the community. One of the things I found with this was that Cox often has other friends write her love letters. She says that Mr. Todhunter has a more elegant hand than she, so he writes them. Her sister and mother read them. They all sit around discussing them. Payne declares his love not just to Sarah, but also to sister, to mother, father, two of their friends. And the reason for the family's involvement is partly about, obviously, reputation. And you see that in any Jane Austen book, like the minute that a Wickham or a Willoughby appears on the scene, then everyone has to leap into action because the sister's chances of marriage are really jeopardized if there's a breach of promise case. So you've partly got that. And that you can see here why those policing mechanisms are kind of there. In this instance, you've got an interrogation of Payne conducted by Mrs. Beckett, and Mrs. Cox. We have Mr. Todhunter yelling at him on Macquarie Street that he's a vagabond. So lacking the coercive apparatus of the state to enforce their decision, these informal laws are backed by punitive measures located within the realm of emotion. Shame and embarrassment would be prescribed to offending parties like Payne, to be enforced through social ostracism, gossip, and then I think as a final measure, you have law. Like it's kind of the last thing that they go to. I think the other thing that you can tell from just how public all that is that love, if we're talking about a history of love, love is not the intensely private emotion, that we have today. It is an emotion with profoundly public dimensions. It's really steered by community and by kin. It's not quite the rhapsodic encounter with the self that we like to imagine it these days. So Cox wins the action partly because the love letters presented and read out in court showed evidence of a promise of marriage, and partly on the grounds that she was able to prove her chastity in court. A lack of virtue would have been a complete defence for Payne. But in fact, her biographer, Carol Liston, found that, in fact, and when you read the case, you can see this. There's a part where the prosecution says, you're looking a bit grey, you're looking a bit pallid. You okay? Like he knows that in fact she is 3 months pregnant at the time that she's giving evidence to her barrister, William Charles Wentworth. So they met in the course of it, fallen in love, clearly, and she's now pregnant to him. It's all quite scandalous. And we also know, if you follow her case through, that although they went on to be one of the wealthiest, most powerful families, she was never accepted, partly because she was a product of a bigamous marriage, partly because she had these two illegitimate children to Wentworth, and she lived for so many years as Wentworth's mistress. I think she'd be fine had she stayed in the working classes. I think that they just had quite a different morality, I think. But moving up the classes, I think Lady Jane Franklin kind of says it best. She writes to one of her friends, she goes, yes, Miss Sarah Wentworth, she's handsome, amiable, pretty, but of course not visited. And you can see that architecturally. You can see their exclusion at Vaucluse House, which is the house that they lived in that's still open today. It's a heritage house. And you can see that there's no foyer to host visitors, that there's no place that they would host any friends because no one's visiting them. I feel like the other awful thing that happened to Sarah was her daughter. She has 6 children, and when her first daughter Timmy marries, she marries a lawyer who Wentworth knows, and the lawyer from that moment on forbids Timmy any contact with Sarah. And so Sarah, for the rest of her life, sees Timmy once more when she's giving birth, and she's allowed to help her give birth for that week, and then she never sees her again because that taint of kind of moral corruption is considered to be so great. The other example of her exclusion is that she was invited finally in the 1840s to a ball at Government House. Governor Fitzroy came. He was incredibly democratic. He thought, let's get rid of all this ridiculous snobbery. I'm going to invite Sarah Wentworth. He invites her. Word gets out that she's been invited. It's published in the newspaper, and every woman in the colony retracts their invitation to the ball until she refuses to go. After this, she moves to Britain. as you would. And she ends up dying here with Wentworth. I think that the other thing historically, the reason why that's also significant is if you ever read legal history, and it's wonderful, it's not dry at all, but if you read legal history, often the history ends with the court case. They'll kind of just tally up, this is how many people won or lost, this kind of thing. If you actually go to the litigants, then you can see that a legal victory does not mean a social victory. Legal rights don't translate into social rights. And it's really one of the benefits, I think, of doing biographies of these things. Okay, so the invigilating role played by Cox's family is typical of 19th century courtship practices. This is some of the stuff that was there. As is the absence of an engagement ring or a trousseau, outings to any kind of a leisure arena like picture palaces and dance halls, or medical testimony around heartbreak. All of which we start to see in the 1890s, and which by the early 20th century become fundamental features of most actions in court. So turning from the 19th to the 20th century, I'd like to now discuss how the action changed in response to shifting patterns of courtship in the 20th century. Okay, so according to prevailing histories of the action, and there have been quite a few, or not quite a few, there's about 4 histories of the breach of promise action in the UK and in Canada and America. And all of them generally argue that the story ends with the Victorian era. American and British historians say that by this time, by the 20th century, courts and legislatures become uncomfortable with awarding money for emotional harms, and the breach of promise is widely viewed as a legal action, and I quote Claire Langhammer here, out of step with modern intimacies. But in my own study of Australian breach of promise actions, it doesn't end in the 20th century. In fact, in the early 20th century, that is really when it springs to life. So from 1900 to 1930, I had 523 cases of breach of promise reported in the national newspapers, compared with 211 brought in the entirety of the 19th century. So just in that 30 years, there's more. And that can't be ascribed to demographic changes. Most of the demographic changes happened between the 1870s and the 1890s. So not only are there more cases being reported, the cases themselves appear in radically altered form. More specifically, women start expressing their injury from broken promises in radical new ways. One of the first things that they do is they start claiming for economic loss. And we see this in the case of Laurie and Lindsay. So Pauline Laurie is a 29-year-old woman who earned her own living as a nurse. She boarded with relatives, but dreamed of raising children in the suburbs. As such, she makes a typical, albeit slightly wealthier, early 20th century female plaintiff. Pauline met Alan Lindsay, a bank manager, in 1928, and for 4 years they chatted on the telephone, wrote love letters, enjoyed romantic evenings at the cinema. Like other couples striving for respectability, they marked romantic commitment through financial investment. She saved money for her trousseau, and he saved money for the house. When Alan offered her an engagement ring, Pauline promptly sold her business, moved in with him, and became a full-time carer for his mother. Things went awry when Alan's mother took a dislike to Pauline and told him that she had overheard Pauline confiding in her doctor, Alan's mother's doctor, that she wasn't certain whether she still loved Alan. Pauline denied it. Alan refused to question his mother and informed Pauline over breakfast that they simply won't be happy together. For a month, Pauline attempted to reconcile, but to no avail. "Give me back my ring and my freedom," Alan wailed. "I can't manage 2 women." Pauline also found it difficult to manage, and she consulted Dr. I love kind of imagining that moment. Too much. She consults Dr. Philip Walsh, who, he prescribes her a bromide mixture and diagnosed her with a nervous breakdown caused by heartbreak. A few months later, she also saw Mr. Eustace Murphy, a solicitor, who won her £290 for breach of promise of marriage. So if Alan experienced the prospect of marriage as a loss of freedom, Pauline experienced jilting as a loss of income. She claimed £100 for her loss of earnings, and she also claimed for her unpaid domestic labour. And you see that in the moment where she goes, "Look, I nursed your mum." When Alan told Pauline that he would pay her back for what you spent on the box, meaning the trousseau, Pauline responded, she said, with steely confidence, "No, Alan, it's not only what I spent that you'll have to pay me back. It's more than that." Turning to the court, she explained, "I nursed his mother and I did all the housework for him." She wanted money back for that. In so arguing, Pauline followed a long line of breach of promise plaintiffs beginning in the early 20th century, who with extraordinary chutzpah and innovation began claiming damages for the domestic labour that they performed during their courtship. For instance, in 1933, Kathleen Brown charged Charles Shearston for the 10,000 meals that she cooked him over a 22-year engagement. They valued the meals quite high, and she won. And in 1920, Miss Exton successfully claimed an extra £90 for services rendered. These are just some of a few. There's quite a lot of these cases where she claims lost wages for housework. So in making these claims, women are obviously blurring the distinction between labour and love. They're exposing the economic foundations of romance and demanding financial redress for squandered care. But these claims also suggest that arguments for the economic valuation of care, all the debates that we're having at the moment about domestic labour, that they don't begin with the middle-class feminists, which is the argument that you often hear. When we talk about this, we go to the 1970s, wages for housework campaign. If you're an Australian historian, you might go back to the 1930s to Linda Littlejohn. She starts to talk about it. And that's as far back that I've seen. But in fact, it's working class women who are used to having their domestic labour given a financial value that I think are really the first people to be arguing it. I do feel like I need to write a little article that just it just seems like one of the more interesting finds, I think, in this, if we could actually trace that back and possibly even look to see whether the middle class feminists were influenced by the working class, by these cases. The middle class feminists at this time hate the breach of promise action. They think it's very demeaning. So it's quite interesting the way that they're using it. Okay, Pauline Laurie differed from the large majority of litigants in that Allen admitted the breach. So the only question for the court was that of damages. In cases where the promise itself was under question or when men argued for mutual rescission, mutual exoneration, the court demanded that women perform their dejection. And this is new for the 20th century. Generally in the 19th century, no one's asked to perform any kind of, suffering. It's just assumed that, of course, you've suffered a lot. But by the 20th century, you really start to see performance of suffering being demanded. So, for instance, in Jaeger and Cull, the defence won because the plaintiff, according to the judge, and I quote, said nothing at all about wounded feelings. There was no suggestion of a broken heart. The plaintiff had been unusually lively in the witness box. She'd even congratulated herself on having escaped marriage with the defendant. The action was not for damages in respect to suffering and humiliation. It was simply an attempt to turn the court into an instrument of revenge, she argued. So if calm deliberation jeopardised the plaintiff's action, then passionate outbursts guarantee success. So when Mr. Schwabe jilted Miss Henry, she stabbed him with a hat pin. Miss Bushby broke her umbrella over the head of Mr. Beardsall, while Miss Caulfield met Mr. Edge on a park bench on Flinders Street, pulled a pearl-studded shotgun from her purse and fired 4 shots at him. She missed, but was acquitted on a charge of manslaughter and, like all those other women, went on to win substantial damages. One of the interesting things about following an action, like the same action all the way across time, is you just see these wide variations in in human behaviour. And this was really, I would say from about the 1890s to the 1920s, it stops in the 1920s and women start to self-harm a lot more. Like they start to claim, suicide and things like that. But there's this extraordinary little pocket where women become really violent. And the courts are fine with it. So, contract treatises recognise that mismatched tempers may be pleaded in mitigation of damages, but judges have nothing to say about that. They suggest otherwise. So after hearing that Miss Cooper gave Mr. Barnett, and I quote, a smack in the face such that his hat fell off after catching him strolling off the ferry in Hobart with another woman, the judge blithely responded, I've often wished that a woman had the physical strength to give the man it back. Good. When Miss Bentley in 1913 told the court that she'd continued to entertain the duplicitous Mr. Clues, who had seduced her, the judge asked, but why didn't you throw scalding water on him when he came into your house? You would have been legally entitled to do so. So, why would a bourgeois court suddenly condone this behaviour? So one explanation is that women's expanding public freedoms at the turn of the century, well, this is the argument that I kind of made, that their expanding public freedoms at the turn of the century intersect with a campaign to reform male sexuality. As Victorian strictures of feminine comportment were discarded, women experimented with anger in ways that I think correspond with their new political rights. And I think I agree. There's a historiography in Australia that sort of says that women become far more constricted by the 1920s, that really if you compare the 1920s with the 1890s, by the 1920s, you've got commodity culture, you've got the ideas of the flapper, you've got a very emaciated form of femininity that's being promoted. The 1890s, whenever anyone asks what period I'd go back to, I'm always like, 1890s, obviously. But yeah, you've got this campaign to reform male sexuality at that time. And so the courts that are keen to enforce a model of domestic familial responsibility by, the early 20th century, you've got the Harvester judgment. So you've got that kind of that model being promoted. And I think that they are willing to outsource punitive power to the women who bear the brunt of masculine sexual entitlement. There's another way, however, to prove injury, and that's to summons a doctor. So drawing upon the notes that he took at the time, Dr. Walsh reported Pauline's symptoms as typical. He said she had a very worried appearance, face drawn, eyes looked red, skin dark under the lips, muscles of face twitching, melancholy tone of voice, pulse 95, soft, slightly irregular, tremor in the hand, loss of appetite, can't concentrate. After this, he says, look, it's going to be 3 to 6 months before she should go back to work, before she could start the business again. He diagnoses her with heartbreak, which he also says, it's because she felt strongly the injury to her affections. So like other 19th and early 20th century women, Pauline Laurie drew upon new medical knowledge to explain her suffering, and in so doing marked a shift from Victorian expressions of grief, such as tears. If you're a Victorian era lady, then generally the most evidence that I found were people kind of dissolving into tears, sleepwalking. There was a lot of evidence about sleepwalking, sisters standing up going, none of us can sleep. She shrieks down the corridor. Or generally, confining yourself to the room. By the 20th century, you have a psychosomatic language of nerves that starts to creep in. So in my database, the 1880s and 90s are the period when a language of health starts to appear in women's testimony. But the descriptions are never that much more precise than, she fell ill, or she suffered in health. The period before and after World War I, however, mark a shift towards a psychological language of shock, nervous breakdowns, and neurasthenia. For instance, the counsel for the plaintiff in Tidwell and Pearce in 1909 argued that the sudden breaking of the engagement gave her a great shock, resulting in extreme nervousness. She's unable to sleep and had been obliged to undergo medical treatment. In 1918, Miss Broadhurst gave evidence that Mr. Archer's letter gave her a terrible shock, resulting in neurasthenia. Miss Chadwick, also in 1919, claimed that she also got a shock. Her nerves and eyes were affected. She had to start wearing glasses, she said, as a result of the heartbreak. So, and other women claimed that they couldn't use their arms, like they're very physical kind of physical manifestations. Why did women begin describing, being jilted in this way? And how did the law shape the kind of testimony that they're able to bring? I think that the answer to this begins in a broad sense in the 19th century, with this slow process of secularization in social thought, where science challenges the explanatory power of religion. Doctors have a new role to play in public debate, and by the 1880s had sought to consolidate their authority through professionalization. The late 19th and early 20th centuries witnessed science placed in the service of social reform movements, aimed at curing the perceived social ills of high crime and unemployment, and a birth rate that had been steadily declining since the 1870s. Psychology also gained greater legitimacy in the aftermath of World War I. Rates of voluntary admissions rose dramatically in the 1920s as the categories of mental illness expanded to include more stress-related illness, such as, and I quote, disappointment in love. So if women's ultimate goal, according to pronatalist and eugenicist discourses, was motherhood, then being jilted now meant a pathological deviation from a biologically predestined path. Love could make you go mad. But as judges often like to opine, there was also nothing new about linking love to madness. From Dido and Aeneas to Shakespeare's Midsummer Night's Dream, love has often been depicted as a divine delirium, condemning its unhappy protagonist to an exquisite torture, culminating in death. But in Australia, it was rare to seek medical advice over love until at least the late 19th century. So part of my research for this, I went to the asylum records and down in Victoria, and found that in the Yarrabend Asylum case patient records, the first person to be diagnosed with dementia caused by, and I quote, disappointment in love, is Janet Wilkinson in 1883. After this, cases appear quite frequently. In 1906, the cause of Alice Graham's delusions were listed as both disappointment in love affairs and heredity. 1903, Sarah Pinn suffers a 3-day case of shock, she says, and I quote, that was caused by reflecting on the character of her lover. I love that idea that she can't, 3 days, she can't move. She's been thinking about her lover. By 1914, the Inspector General for the Insanes report for the year 1912 listed love affairs as a distinct category under causes of illness. So I kind of went through all of those reports, and that's when it starts to appear and continues on after that. So you start to have the medicalization of heartbreak, basically. So over the course of the 20th century, as people became less inclined to accept the strictures of religion, family, or law when it came to romance, they became more likely to consult psychologists. In extreme cases, like the above, you can see that, or simply psychological literature, which by the mid-20th century could be found everywhere, in agony aunt columns, in magazines, self-help books, psychology clinics, workplaces, and cinemas. Like law, psychology channels individual stories of suffering into a universalist language. But unlike law, as Eva Illouz has argued, psychology relegated the romantic and the erotic to the individual's private responsibility. We see psychological or therapeutic discourse washing up in breach of promise cases as part of the flotsam and jetsam of romances that had run aground. The sex manuals admitted as legal evidence, love letters brimming with stories of dreams, and the descriptions of heartbreak in terms of nervous shock. Courts, as profoundly polyglot institutions, absorb these new psychological languages that are used by litigants, lawyers and expert witnesses, and they order them into juridical logic. From the early 20th century, we see psychological discourse coexisting with law and over the decades encroaching upon its domain. It's like a wartime map. Its colours blot and bleed, expanding into more territory, quietly colonising inner worlds, until eventually people stop bringing actions in the 1950s, preferring psychological advice to the judgment of the court. These changes also intersect with shifts in the operation of civil law, as the courts narrowed their interests in people's amorous lives from the vast terrain of courtship, with its rituals, gifts, romantic wounds and letters, to the contract of marriage and its aftermath, property taxation, migration, custody and wills. By 1976, when the action was finally abolished and the family court established, civil law has disavowed its authority over romantic emotions and declared courtship beyond its jurisdiction. One of the things that happens when the Family Court Act is introduced in Australia is that they also hire a bunch of psychologists to come in and do that work. So it is quite an explicit sort of moment. Individual couples, rather than the state, now define the terms of courtship and marriage, aided by a government-funded army of psychologists. Admittedly, the nation's lawmakers never stopped caring about love, or particularly who and how we love, though. The same-sex marriage debate in Australia in 2017 highlighted politicians' investment in perpetuating a model of marriage based on lifelong monogamous heterosexual partnerships. The success of the yes vote also revealed the political power of love as a protest against law's exclusions. The primary argument offered in favour of same-sex marriage was an appeal to love's timelessness and universality. Love is love, proclaimed rainbow-coloured banners across Australia. What campaigners meant was that love is a self-evident good, common to all humans across time, regardless of social encumbrances like race, gender, class, or sexual orientation. And I think my book is both an affirmation and a refutation of that catch cry. For there is obviously something fundamentally human about falling in love that allows us to feel the amorous tremors of love poetry from Sappho or Byron, although centuries may yawn between us and the poet. But love is also not just love. When we see doctors giving testimony about the medical effects of heartbreak, or read of Beatrice Story turning around after her court case and marrying Frederick Chapman, or we applaud women at the start of the 20th century for claiming damages for all the dinners that they cooked their lovers, we know that we're dealing with an emotion that is profoundly shaped by culture. Love is a creature of its time, and it's in the space between strangeness and familiarity that the history of love can be found. For Australians in particular, I think that a history of love told from the papery relics of one of our most treasured national icons, the working class battler, I think that that history is a corrective to traditional histories of love that tend to favour the bourgeoisie and an antidote to our anemic national mythologising of stoic, independent blokes and robust women. Then Frederick Chapman may have been a stockman, a larrikin, and a spinner of yarns, but he was also nervous, he was sentimental, and he was smitten by Beatrice Story. And far from being a long-suffering heroine of Australian legend, Beatrice took her squandered affections to court, and she won. Writing a history of courtship from the archival remains of broken hearts allows us to tell national and transnational stories of vulnerability and resistance, of our fierce and fragile inner worlds. Thank you.
All right, thank you very much. I did promise a treat, and I think Alecia more than delivered. Is time for questions, but I am going to take my prerogative as chair and just jump in there. This is great, fascinating, and also very rich, the way that you think through the individual cases to create this narrative that's so much more than the sum of its parts, I think is glorious. I was wondering about the money, so the damages themselves. Can you see a pattern in the amounts awarded to and the claims? Were women awarded more earlier, more later? Is there a pattern, or is it sort of haphazard and random based on the laceration of feelings in individual cases?
Look, it tends to... The idea, I think, with the damages is that it works as a kind of dowry for the woman. So on the one hand, your reputation has suffered. On the other hand, a bloke might be willing to overlook that if you're coming with $180,000, for a working class woman. That's quite a lot. I wish that I had another set of slides here. I have a precise answer to that. I hired a research assistant and I actually tracked it over that period. The average in the 19th century was £100, so 180,000, and that remains pretty constant. The main differences that you find is when wealthier women sue. So it's all working class, but every now and then you get an aristocrat. Very few middle classes, which kind of conforms to a lot of historical, history generally, which is the working classes and the aristocracy generally, aren't that as concerned with propriety and privacy as the middle classes. So when they sue, they get a lot more money, and that's just because the guy's worth more. So that's the correlation. It's about how much he's worth. It just tends to track really across the centuries based on how much you would need really to survive for, say, 2 or 3 years, by yourself. Sorry, the other key difference is in instances where she's got a child, she might get a little bit more, which is interesting, isn't it? Because it's not the usual story that we tell about, the shame of having a child out of wedlock. It actually shows, I think, the extent to which the community or the courts are sort of saying, well, if we don't get this from the guy, then the community is going to have to pay for that. There's no parish structure in Australia for most of the 19th century. So where do you get it from? You get it from these charitable institutions that are not very well established, that don't have that much money. So... which is why I think why it's so strict. The other part with the damages that's interesting is that that men will go to prison if they don't pay. It's really, you can't get out away from it.
All right, I will now do the honest thing and hand over to actual audience questions. I'm sorry. Yes, 2, 3, right?
Thanks so much, Alecia. I really, really enjoyed your discussion. And I was going to ask you a different question until you started talking about the women who were using the hat pins. Because as you were talking about the suing for breach of promise, I was thinking of cases I've come across in my own research of women who actually take direct action against the men. And you may be familiar with the Ethel Herringe case where he promised to marry a woman. She was a barmaid, and he reneged. And she said to him, that if you renege, I will shoot you. And he did renege, and so she shot him dead. And there was a big case in Sydney and a big campaign to not have her hang, led by the wife of Holman, the Labor politician, May Holman. And it got a lot of support, and she didn't hang. And again, in 1938, a case of a woman who, again, he reneged. He said that he would marry her. Turns out he was already married. So she slashed his face with a razor, and it went to court for assault, and she was let off by the court on the grounds that he had it coming to him.
Yeah.
So there's kind of,
I
was thinking,
interesting.
Are there different sorts of women? But clearly they're not quite different, because the hatpin women suggest that they're taking direct action and they're pursuing through the courts. What's your feeling about
I love that? Yeah, I feel like we can take that as a comment in some ways. It's just, yes, I feel the same way. It's really interesting. I mean, look, I think that what I noticed, look, maybe it's not something that I wrote directly on. I did obviously, discuss it in the book in these kinds of terms, but I feel like there would be a good article on women's violence in that respect, and maybe it complicates my argument a little bit more. That because what I saw generally was what I thought I saw was kind of women dissolving into tears, taking to letters, and then they become very violent, and then suddenly you have a whole series of them saying, I'm going to commit suicide, and self-harming, that sort of going on. But you're right. Now that you say that, I'm like, actually, and I could think of a bunch of other cases. There's another woman in Albury who shoots her lover dead around that time as well. They do continue even through to the 1950s. I remember reading another one about that. So perhaps it's better to see them as coexisting. And the interesting question is the extent to which the courts are fine with it. Like at what point, which I wonder is part of a broader question around crimes of passion, and the extent to which that has always existed in law to mitigate wrongdoing. Like that's always existed in law as something that can reasonably be argued, and through to even the homosexual advance defence, very recently, that was all about, well, he felt disgust, therefore he had a right to do that. I think that they're interesting in a legal philosophical sense, because the law likes to imagine itself as as entirely absent of emotion, as the place that is monolithically kind of sober and the a sort of monument to reason, whereas in fact it condones it, and in condoning it, that then becomes part of the law. I feel like that should be another article. Maybe we should write one together.
This is a generative discussion.
Thank you very much for the very interesting discussion. And I'm glad you mentioned that someone was murdered in Albury, because that's where I'm from. So it's very interesting, and I didn't know that. My question was, I'm just really interested in about how the law came about to be repealed. Was there a specific event that led up to it, or was there some kind of campaign?
Yeah. It's interesting in Australia. It was, repealed here in 1976, same in the UK. So it's around the same time. In America, it was repealed in the 1930s in a lot of states. It's kind of state by state. And there's a range of reasons. If you read the Hansard articles, they say, it's out of step with modern intimacies. Women are now not dependent upon marriage. But the main argument that I found was that it's being used by gold diggers. So there was the gold digger myth that kind of the reality is, in fact, it's working class women who are using it in circumstances where they're quite desperate and I think quite resourceful. The other interesting reason as to why it was repealed in Australia, and there was a part in my book where I kind of hit the 1930s and I was like, I should go on to the 1950s because by then, and this was a reason for repealing it, it's largely migrants who are using it. So it's Greeks and Italians. And so in Parliament, they say it's only immigrants who are using it anyway. We shouldn't have it. So if you've got any students who are looking for a topic, like an honours topic or something, the cases are fascinating and no one's looked at them from the 1950s through the 1970s. And those people would all still be alive. So you could do, or some of them would be. So you could do oral histories with them. Anyway, yes, if there's a student who wants a topic. So they're the reasons. Yeah.
Thank you so much. I have a comment and a question. The comment is, I have a friend who was left at the altar a decade ago. It was quite scandalous. I mean, a lot of people in Melbourne still talk about it. But I think I was on a flight home for the wedding and was told the wedding was not happening. What was really interesting was the fathers involved. It was a very long relationship. The fathers involved negotiated the settlement. So communities are still involved in those settlements. There was a house, there was a shared dog, there was a whole lot. So it's just a comment that community involvement still happens, and it was sort of left to the two fathers to negotiate the settlement, and she went on honeymoon with her sister and is now happily married with 2 children.
Isn't that interesting?
It ends well.
But they come in at the point where there's property involved.
Yes.
Is that it?
Yeah, exactly. It's fascinating.
Yeah.
The question I had, I thought you'd enjoy some more generative discussion. The question I had was around cases that don't make it to court. So I'm an inveterate reader of Georgette Heyer novels, and there's a lot in that around, which is sort of Regency period UK romances, but there's a lot in that around working class women or prostitutes threatening to bring a breach of promise against an aristocrat as a means of getting money out of the family. That is a kind of a common, that gold digger narrative is a common narrative, particularly around kind of, prostitutes and long-term courtesans. And is there anything in the records around kind of things that don't make it to court, but threats of breach of promise that are used to extract money by women, whether legitimately or not, or who are kind of, sort of industrious in that way?
Yeah. Look, I think that's a common trope in literature and in plays at that period. The middle classes really don't like the breach of promise suit. And so everything from Pickwick Papers, through to, trial by jury, it's ridiculed and it's seen as schemers, as an action for schemers and gold diggers. Whereas the actual cases, as in my database, were definitely all working class. The ones that don't make it to court, the reality of it, you can trace through maintenance cases. They often settle for breach of promise outside of that. And again, look, I'm very suspicious of the gold digger trope. I don't think that's there. They tend to be very poor working class women who have now got a kid and they want some money. That's it. I think that it's a, and I mean, isn't it there in that Marilyn Monroe? It is in. Gentlemen Prefer Blondes. That's got a breach of promise thing in it, and that is all it's classic, kind of gold digger stuff. But I think that it is a product of literature more than reality. I would say. That said, I did find a few swindlers, and thought they were great. but they're very much the exception. Yeah.
Thanks so much. Thank you for the wonderful talk. I'm going to ask a couple of unrelated questions, if I may, and then Agnieszka's tasked me with a very important job of going to see where the wine's got to. So I will slip out after your answers, but it's not because I've been offended by what you've had to say, just to reassure you. So the first question is, did you notice an uptick in breach of promise cases during times of economic downturn when there was perhaps more at stake, and or during the two world wars?
Yeah.
And then the second question is, can this history of love also be possibly interpreted as a history of liminence? This kind of drawing on your kind of psychological framings, this kind of misplaced attachment, infatuation, has a sort of psychoanalytic meaning, but I'm just wondering if it's about love and also about liminence.
How lovely. They're such contrasting questions. It's like the structural and now the psychoanalytic. Yeah, definitely. The 1890s, huge increase. And similarly, that's the period that's known as the divorce boom in Australia after World War I and after World War II, like a spike for sure. So yes, that's definitely the case. The 1890s is a depression. 1930s, 1929 to 33, I don't think I saw a massive, look, I'd have to go back to that in particular. It's always this thing when you give these talks where you're like, I don't know, I wrote that 8 years ago, like, you know, like that particular section. As for the infatuation and liminence, it's lovely. Look, I think that one of the interesting things that you see with the breach of promise is that when you're looking at it as a history of love, is that there's not really that much love as we know it. In the 19th century, it tends to be very practical. It tends to be very kind of, you know, he came in, used to come into my store. One day he said, how about being my wife? I said, well, show me your property. He said, all right. I saw it. We were married. Like, you know, we were meant to be married. That kind of, like, that just happens again and again and again. It's just not, like, it's practical. It's very much, and this is the argument that Claire Langhammer makes as well, that there is a luxury to liminence almost in a way, that there is a kind of a financial luxury to romance as we know it, that she tracks to the post-war affluence to 1950s. And I think that also helps to explain why there's a decrease then in it. However, I do see a lot of infatuation cases, like you see the beginning of those cases that look a bit more like that. I think there's one in particular that's about a slapper in Perth in 1916, which is a case I really enjoyed writing about and reading. And she's absolutely like, you know, it's so fantastical, her visions of what this guy is. And I think to have that, you have to have, I think that Warren Sussman's theory about the shift from character to personality is really interesting to that. In order to have that, you have to have a shift from love as being around duties, virtues, you know, honor, like promise keeping, something that's legible to law, that is largely kind of has one foot in the public sphere, one foot in your inner world, to something that is a rhapsodic encounter with the self. And I think that happens in the 1920s. Sussman traces that in that arc from character to personality, where he says, you know, subjectivity, the self changes in that period, and it becomes more antinomian. It becomes more kind of, it's that idea that you can plumb an inner self, which is obviously about, you know, Freud's, the uptake, I think, of Freud's ideas. It's about the decline of the church. There's so much that happens, you know, in that period in particular. And I think that there is really a new self that emerges out of that makes sense of the notion of liminence. I don't think that it makes as much sense prior to that. Yeah.
You've got a task, I believe. Rosa?
Thank you so much, Alecia. It's such a fabulous book, and thank you for the talk. I have a comment, which is, and then I have a question. And the question is, so you can think about it, is what next for you? What are you working on now? And where did this take you? But my comment is about wages for housework, which I think is such a great link that you've made, because, and obviously, I mean, not obviously to everyone, but I work on the 1970s. I've worked on wages for housework, the movement. And I guess the way that I have heard the prehistory previously told has been through, for example, Mother's Benefit, Eleanor Rathbone and Susan Penderson's work on her, or Laura Schwartz's work on domestic service unions of servants unions in Britain, both in Britain. So I think you should definitely follow that up.
Interesting.
Like you should definitely write this article. But I guess I have 2 points, which is that the difference, I think, is that unlike the 70s, this earlier moment, it's not a revolutionary perspective. So it doesn't seek to change the world through valuing care in the way. And the other thing is that I think actually that wages for housework women were working class. So like these earlier women, and I only make that point not to make a historian's point about how they were really working class, but because what's interesting about that is because that was the way that they tried to differentiate themselves from other feminists and be useful to working class women and to appeal to working class women in exactly the same way as your women did.
Is that the 1970s campaign that you're talking about?
Yes.
Because Linda Littlejohn is very aristocratic.
Yes.
Like, yeah.
Yes. So and Eleanor Rathbone is, she's more bourgeois as well.
Yeah.
And
but that's interesting.
But yes.
Are they the Italian one?
And also Selma James working here and in the US.
Okay, yeah.
And then black feminists who are working in Trinidad and Tobago and in the US as well, and bring questions of the environment in. So just, anyway, I only make that point because I think that's a kind of similarity between them.
Yeah.
Yes. But anyway, let's hear now about what next for you.
What next?
Thank you.
I mean, to be honest, if you've seen the book, it's quite a tome, and I was a bit exhausted after it. And so I have just been writing little, bitsy kind of things. But I had a chat to a friend who edits Cambridge History of Law, and she was like, why didn't you ever publish a PhD? And I was like, it's true. And so I'm returning to the PhD, which is on, it was actually on discourses of friendship in cross-cultural friendship in British Oceania. So I was looking at how friendship and law could be spoken on both sides of contact, in cross-cultural contact situations by voyagers, traders, and then by government. And so, so I found that interesting in that in international law at that stage, or the law of nations at that stage, you had a right to friendship that could be enforced through killing, which is, so a right to friendship basically gave you the right to sojourn or the right to trade, and if they said no, so this goes all the way back to Victoria in the 15th century and continues through to the 19th century. So I was interested in how you see that on the beaches of Pacific Islands, how you see that playing out. And so I'm returning, I'm returning to that, and I'm starting to look at missionaries actually with that, and we'll finally get that book out. So that's the next will be friendship. And then I think actually like a similar kind of courting style book, but on friendship actually would be really nice, or on the family, like something that looks at that. I should get out of intimacy at some point, but they're such good stories. Last question. Sure.
Thanks so much, Alecia. And thank you in particular for, in this digital age, reminding us of the mystery and the magic of the archive. I think we were all with you flicking through that file tonight. It's gorgeous. The question, I mean, you've drawn extensively on the court reports, the judgments that are passed out, and also the editorialising that goes on. But there's that other public trial, isn't there, through the correspondence columns of the popular press. Yes. And I was just wondering whether you wanted to comment on that. I'm thinking in particular of what Marilyn Lake has argued about the masculinist sections of the masculinist Labor press that may have given voice to a different kind of critique.
Yes, absolutely. I think that it's like newspapers themselves. It's hard to say one thing. It's very multifarious. But as I was researching it, I did think that it was fascinating that there was so much discussion in the newspaper's commentary section about breach of promise. Everything from, you would have almost like an agony aunt style column. So it'd be someone sort of, answering readers' questions, and there would always be a breach of promise, thing in there. So they're kind of offering legal advice, in a way, but also discussing the ethics of love there. And they're generally in favour of it, through to, and it was something that I found when I did the biographical parts, like that then made me look in depth at all the commentary that you see going on around these cases. And the Bulletin in particular had a field day, with them. Like they just thought they were hilarious and, didn't really see the class dimensions to them. They just saw them as scheming women, really. And then otherwise I think that they were just kind of, you see them being commented upon more and the uptake more after you got the tabloid press in the 1880s and the 1890s. You see far more discussion of them then, but it's really just in very sensationalist kind of, sort of tones, and not necessarily disparaging in the way that you'd imagine. For the most part, people continue to boo the guy and, cheer the woman, as they do in the 19th century throughout. Other than by the time that you sort of get to the 50s and 60s where it's just kind of seen as a bit odd, and why are they still bringing this. But you're right. There's absolutely this broader sphere in which it's being discussed.
All right, and to the maudlin love songs from the ice rink behind us. Can I ask you once again before you join us for a drink and continue the conversation with Alecia, to thank Alecia Simmonds for an absolutely glorious Reese lecture.
Thank you so much. It's a delight. Oh,